speakers 3.5 minutes, and I've got a watch, and at 3 minutes, I'll hold up my hand or wave, which means you wrap it up in a half a minute. And one person has been very, very exceptional on this is Mr. Tanguay. You have been the time management rock star. So I've got a pink card from you, and if you would like to come up, 3 minutes once you turn on the mic.
Thank you, Chairman Pearson. I wanted to just start out with discussing the previous bill that I was listening to. I am in support of the
That will
bill.
take out of the minutes here if you wish.
Yes,
Go
sir.
ahead.
For the recording in the court, I do agree with that. However, there's an amendment that I will suggest, and I know that you're not able to exec these right now, but the restrictive language, Article 8 says that the government shall be held accountable, and that allows, in my opinion, for us to record in the courts. And so therefore, I ask that you guys remove from the bill anything that restricts anyone from recording. You can record, the court can restrict what you publish. Okay. So even if something's private. Now to this bill, I am in support of this bill. I think it's a great bill. There was a lot of care that was put into it. For one thing, that the parties get to decide at the front end to use the court services, and then on the back end, before anything's submitted, they're able to decide whether or not to do that. There is one thing that I am concerned with, though, however, and that is the requirements to become a appointee to help out. I think that that is restrictive. I think that we do need some more people who might be interested in family law and families that aren't in the echo chamber of the legal construct, and those requirements to have, I agree with the requirements to have training. However, the requirements to have a specific education, I have a GED, I'm articulate, I'm well read, I can understand these laws, and I think that will alleviate and bring some other people in, providing that they do go through the training. And with that being said, I'm all set. If there's any questions, I'd be happy to answer them.
2 minutes and 20 seconds.
Bam.
You are on a roll. Any questions for Mr. Tanguay? Nope, seeing none. Thank you so much.
Excuse me. Thank you. I'm asking your guys' help with some questions. I do know quite a bit about family court. Rule 1.2, right? If you read the family court rules, Rule 1.2, a judge may waive upon good cause any rule. That's right. Unless prohibited by law. So I'm in support of this bill because it kind of guides but also restrains the very, very new judges in a very, very new court system, special court, family court, created in 2005, the family division. The family court was created in 2011, and it's basically been terrorizing pro se litigants since its inception. I'd like to speak about 633:4, interference with custody. There is a misdemeanor offense in which you hide the children from a parent, and you can argue that 633 is actually, it says, if you read the language, a parent, if that means even if you have court orders saying that there's custody at this time, but if you hide the location, I assert that you have the right to know where your children are at any point in time. So it's a felony when it's over the state and there's no justification, not preventing the abuse of the child, nothing. You have to, within 72 hours, if you're going to hide the location of a child from a parent, which happened in my case with a police officer, and the police don't do anything about it, the amount of pain that someone suffers when their children are removed from their understand it. You can see this in slips, permission slips. You can't take your children, the school can't take their children on a field trip. You have to know where your children are at all times, and that's the way it works. So this bill gives the court clear guidelines and the litigants clear guidelines to do a simple procedure, and the court does have decision-making ability whether or not to impose that fine, and so they do have, but they can't waive that right. Where if you file contempt motions, I've filed contempt motions, just not regarding to this. It's an important bill. I do not think that there should be jail time put on that, because then that leaves the court to abuse a unpreferred litigant. To jail time it's a big thing, man. You have to really do a crime, and if you read the legal statutes.
30 seconds.
Thank you. And I will state that in my case, so when you look at 173B is unconstitutional, right of the accused. That's domestic violence protection. And 633:4 is a form of domestic violence. When you're ordered to do things with the court, I'm going to run out of time. So maybe we'll have to save that for later. But I do support this bill. I don't really see any amendments that are necessary, and I'm open to any questions that you might have about 633:4 or the court rules contempt process, because I am familiar with that.
Sure. Any questions for Mr. Tanguay?
Come on, guys. All right. It's the rules.
Yeah, but you get one more bite at the apple today. Thank you, sir. And former Representative.
Right. Thank you. I say let it snow. It's all good. I am opposed to this bill, actually, respectfully, because of I know the hard work that's been put into it. However, as I've stated before, but not really indirectly into this bill, there's a statute on the books from the Uniform Support Act of 1955, which states that basically assets shall be considered, as the Honorable Betty Gale just gave. I'm sorry, I was getting back into the 50s. Stated is that the child support group gets their. The states get funding by the amount of child support that they award, and therefore they want to award child support, and that's just wrong. I don't think that child support is something that should be awarded. And then when you look at how the law is actually applied, we have standing laws where it says assets shall be considered. The relative wealth is the specific term of the individual families. That's already there. And that should be on the child guidelines worksheet, and it's not. So that's why I don't, and I also don't support a bill that acknowledges 173B domestic violence protection orders civilly, because it's against the Constitution. Article 15 of the Constitution of the state of New Hampshire, rights of the accused, says that in order to take away any privileges, property, anything, you have to go through due process, meaning you need an arrest. So that's saying, part of this bill is saying that this will apply unless there's domestic violence. By the way, 173B is unconstitutional, and it's being used to strategically get the person who's claiming domestic violence money, child support, time, complete control of the children, verification of the record, and also like defamation. Like they put these things that are false. And it's also, before the special committee, Chairman Pearson, we actually heard the famous Judge Pauley case in which the police did not arrest the person who ended up shooting her in the face. And also the Domestic Violence Coalition never showed up to the final protection order. So the police failed to follow the law when there was signs of physical and sexual abuse. There was evidence of it, and they said go file a civil protection order. So we need to be working on repealing 173B and enforcing the police to arrest people who violate the laws. And then we need to be acknowledging laws that state that child support shall be considered by who the general assets of and wealth of the individual parties, the ability to earn, and so on. And then we also have to consider that in some cases, child support is not necessary in any which manner. What a parent spends their money on for their children is a free speech. It's been acknowledged in political contributions federally. It's free speech. If I want to buy my child a ring ding, I can. If I want to buy them a library book, I can. If I don't want them to have a brand new iPad, I shouldn't have to. If I don't want to pay the mother's mortgage because she wanted to end a relationship,
You got
I
a
shouldn't
minute
have to.
left.
Okay. So I don't support this bill.
Okay.
Thank you. And for those reasons stated, and I just want to really hammer in that 173B is unconstitutional. I'm challenging it with the Attorney General and the state. And we shouldn't be using funding for federal money to basically force payments through the state. And there's actually a constitutional amendment, which I was trying to look up, that says basically the state can't take property away from someone else for the use of public use, which that's what child support is, and that's what I'll contend. But
15 seconds.
I want y'all to be safe and really look at 546 and really understand the spirit of child support was designed to get real deadbeat parents, typically dads that had a one-night stand and had a baby and then ran away. That's what child support was for.
Thank you so much. Any questions for Mr. Tanguay?
Come on, guys. This is good stuff.
I mean, you've got a good sparring partner here. Well, we know you'll...
I think they're in agreement. That's why. And they know it's so true.
Oh, well, I know you'll be back, so we'll work on some things for
I
you.
appreciate y'all.
We're
Thank you.
taking next Tuesday off. Go vote.